Good morning, everybody. My name is Debbie. Welcome to my channel. Like 2 seconds ago, Shadow was up here like she was ready to start the stream. And you couldn't even see me. 2 seconds ago. Sorry. Shadow was up here like she was ready to start the stream. Why is this not stopping? You couldn't even see me. Okay. I was gonna say, hi, I'm Shadow. I'll be running the stream today. She had me completely covered. She was like right here. Good morning. Where is everybody this morning? I missed my friends. Where are you? Come on. Where is everybody? I'm lonely. I'm lonely, people. Where are you? Hey, Judy. Judy's here. The important people are here. Okay, I guess everybody's going to do replay crew today. That's fine. I love my replay crew too. Nobody wanted to listen to Deets today, I guess. I don't blame you.
You're taking a break?
They're taking a break from me?
Yeah.
Yeah, they're taking Travis says they're taking a break from me. At the time of her death, Schaeffer was dating director Brad Silberling. Her death influenced his film Moonlight Mile about a man's grief after his fiancée is murdered. Oh, that is so sad. Shortly after Schaeffer's death, Pam Dauber and her My Sister Sam co-stars reunited and filmed a public service announcement for the Center to Prevent Handgun Violence in her honor. So sad. Okay, guys. I can't see around my camera now. I clicked on the wrong thing. I can't see around my camera now. Oh, Debbie, you're an idiot. Hang on. I thought I was ready to go, but I wasn't ready to go. We are on Dr. Deets part 13. Oh, joy, the Shed Ranch commercial. What is happening? Stop doing that.
Purpose and approach or lure his victim to him for the purpose of killing, with the purpose of killing being concealed. Okay? In other words,
it's been 84 years.
it's not required that he be hiding behind something. He can be standing out front Why don't I just do it in the terms of fact?
Hey, Wiggles. That's why Wiggles wasn't here.
Since I'm not the judge who handled the
He's not done yet.
995 motion to dismiss apparently the special circumstances or reduce the degree of crime, was this argued before Judge Connor?
Yes, it was, Your Honor.
All right. Is
I
that
thought the transcript was actually in the court's record. If it is not,
maybe in the court's record, but again, I am not, since this is a court trial, I am not going to read anything that has to do with this case unless it's in evidence. That is not in evidence.
I would like to mark it, Your Honor. I
Thank
assume that
you.
if it was part of the court file, the court would read it. You're correct. I stand corrected. And I
I'm
should.
not going to assume anything happened unless it happens in this courtroom before me.
I would like to mark the transcript of that hearing, sir,
All right.
as people's next in order.
Ms. Chen?
I would stipulate that the court could consider that. However, based on this last question, I object because I don't believe that that is a complete statement of the law as it pertains to lying in wait, not only as to lying in murder by means of lying in wait, nor as to the special circumstance allegation of lying in wait. I believe that there is more to it than what counsel
There is, I don't think
raised.
she finished the question, and it may.
Okay.
Matter of fact, I'm going to withdraw that.
All right.
Let me start all over. Let me give it to you in factual sense, Doctor, to make it more obvious. If it is the prosecution's contention that the defendant approached her door on the second visit with the intent to kill her, that he went and rang the doorbell with the intent to kill her, and that in the simplest possible of all constructions, at the very least, what he did was stand at her door, waiting for her to come out and open the door with the gun concealed, and waiting for her to open the door once she did, killed her. That's the prosecution's theory. Okay? As it was argued at least at the 995, at the motion to dismiss. Given that theory, sir, and that argument, wouldn't you agree that the defendant's statement admitting to Dr. Stahlberg, if he did so, that he went back the second time with the purpose of killing Rebecca Schaeffer would indeed support that theory?
I'm going to object to one point about this, Your Honor, because there is now being interjected a supposed statement by Mr. Bardo to John Stahlberg. And the statement that is now being purported and put forward, I don't believe that the evidence has established that that is what he said. And now we're
I
getting.
don't recall it being, I think you're right, I don't recall it being that complete.
I believe
But there was a
Camera's
definite
killing me today.
statement by this witness that he believed that the defendant stated to Dr. Stolberg that he had killing Rebecca Schaeffer in mind when he went to the door.
But I think it is very important that we.
I'm talking now about the evidence. I don't know what he told Dr. Stolberg, but
Exactly. My objection, though, is that now we're taking a little bit of license now with what the statement may or may not have been. And I object on that grounds because I think it misstates what the evidence was.
there's clear evidence in this case that the defendant, that this witness knows about some statement that he believes was made by the defendant to Dr. Stolberg to the effect that he had in mind killing Rebecca Schaeffer when he went to the door the second time. I think we can probably find it in the record.
It's in the notes, Your Honor, but I'd like to make it a little bit easier and frame my question in the form of a hypothetical. In view of the evidence that has come in, that the defendant made a statement, I think we can all agree that the statement was to the nature that he believes he may have told Dr. Stahlberg that he was thinking about killing her when he went back the second time. And he's not sure if he said that to Dr. Stahlberg or not, and that he told Dr. Dietz that if he did say that, it was because Dr. Stahlberg upset him with discussion of Rebecca Schaeffer's boyfriend. That's my understanding.
Seems to be pretty accurate as far as I can recall the testimony.
At that point, my objection was to the way the question was
Yes,
phrased
well, I
earlier.
understand that. So,
Okay.
as rephrased,
I would rather phrase a hypothetical for the doctor than go back to that, because I think it's probably more pertinent to the question.
Well, as you know, on direct examination, hypothetical must include facts which are either proven or with leave of court can reasonably be expected to be proven, and neither of those has, if you're going to amplify on the statement.
Wait, doesn't People versus Bush say that the facts do not need?
People versus Bush says that I'm sorry, I stand corrected. This is cross.
Okay.
I presume from the length of the questions that we were dealing with direct, but go ahead. People versus Adolf Bush in 56 cal seconds says precisely what you're about to say.
Thank you, Your Honor.
All right, go ahead.
If I may, sir, pose you the following hypothetical. Given what we understand now to be the prosecution's theory of lying in wait in this case, if indeed the defendant said to Dr. Stahlberg, this is a hypothetical, if indeed the defendant said to Dr. Stahlberg, I went back a second time and my intent was to kill her. If he said that, wouldn't you agree, doctor, that he would rightfully fear that that statement, if it came out in trial, would support the prosecution's theory of lying in wait?
Yes.
Now, no more hypothetical then. Wouldn't you also agree, sir, that knowing all that the defendant did, as I've given you in the other hypothetical, concerning all the events that transpired after his discussions with Dr. Stahlberg, knowing all that he did by the time you saw him on the very eve of trial, that the defendant would have considerable motive?
StreamYard is so stupid. The Halloween stuff, they didn't add until, I can't remember if it was after Halloween or right before. Same with the Thanksgiving stuff. And they just added Christmas stuff yesterday. But it's cute.
To lie to you and to claim that statement to Dr. Stahlberg was a lie.
Assuming he made that statement to Dr. Stahlberg, yes.
Did you consider that possibility, sir?
Yes.
And even when you considered that possibility, that did not cause you to disbelieve the defendant's rendition of the events that transpired on July 18th, 1989?
That's right.
But doctor, when you consider everything that we've pointed out, isn't the defendant's statement to Dr. Stahlberg far more likely to be truthful than his statement to you, since it was made at a point in time before he saw the witnesses testify, read police reports, heard the argument and the prosecution's theory in the case?
There's no evidence that Robert Bardo ever read police reports or read my motion or anything like that.
Let me back up. I'll restate it. Okay. Wouldn't you agree, doctor, that the defendant's statement to Dr. Stahlberg is far more likely to be truthful than his statement to you, given at a point in time as it was, prior to seeing witnesses testify at a preliminary hearing, prior to hearing the prosecution argue its theory of lying in wait in the case, prior to being incarcerated for 2 years with other inmates and discussions with lawyers? Don't you think?
Well, first of all, I'm not sure there's a real contradiction between his statements to Dr. Stahlberg and his statements to me. What I recollect him telling me he may have told Dr. Stahlberg is words to the effect of he was angry with her and he purposely killed that bitch, something of that sort. I'd rather find it in my notes or on the tape because I don't have a precise recollection. But he did not tell me otherwise with respect to having intentionally shot her when he did. And he admitted that to me too.
He admitted that he intentionally shot her when he did, but he did not admit going back a second time for that purpose, correct?
Exactly.
All right.
Can he tell you that he told Dr. Stolberg that he went back the second time with the idea of killing her, or thought about killing her when he went back the second time?
At this point, I'm not sure, Your Honor. That's why I want to find it in the notes.
You have already testified to that effect, though, have you not, and gave an explanation that he was angry because of the boyfriend situation?
I recall his saying that he got angry, that Dr. Stahlberg made him angry, and that he spoke in anger to Dr. Stahlberg. What it was he said to him in anger is what I don't recall with any certainty.
Okay.
Well, was it something to the effect that he had in mind killing Rebecca Schaeffer when he went back the second time? Yeah, you can, if you need to read the notes to answer, please do. What page are we dealing with so I can follow along?
Your Honor, we're referring to the, I'm referring the doctor back to his notes that pertain to tape 2. And that was testified to yesterday.
Yes,
Not yesterday.
day before.
Day before yesterday.
Because I remember reading it and I haven't gotten far enough in yesterday's.
Shall I read it, Your Honor?
If you wish, go ahead.
At least one of the things he told me about Dr. Stahlberg was from the second day, the second tape, where he said, with respect to going back the second time, I'll tell you what I was thinking in my mind. All I was thinking in my mind is that I was thinking that it would be easy to have her talking as she did, where it would just be me and her. That's the thing that was mostly on my mind. Really, I think I told Dr. Stahlberg that I was thinking about doing it, but I'm not sure if I did tell him that, because I don't know from what because what he said to me, I was kind of pissed off at him, because he was talking about her boyfriend and all. But I don't seem to recall that, if I did,
So to you, he acknowledged the possibility that he might have told Dr. Stolberg that he was going back to kill her the second time, or do it, as he put it.
Yes, sir. On this occasion, that's what I think he's saying. There was another time when he talked to
And he
me about...
gives as a reason for that he's irritated with Dr. Stolberg?
Yes.
Does that make sense to you?
Well, what does make sense to me about this is that he got angered by Dr. Stahlberg, who provoked some jealousy, and Bardo thereupon conveyed to Dr. Stahlberg a greater sense of animosity and anger at Rebecca Schaeffer than he in fact felt. But
is it also possible that in talking Dr. Stolberg in a state of anger, he slipped and let be known something that he intended to keep quiet?
yes, sir, that's possible too.
All right.
Is it also possible, Doctor, that when the defendant told you that he made that statement, if he did, to Dr. Stahlberg, he gave that excuse about getting angry, he was lying to you?
That's possible.
So that what he was trying to do was undermine a truthful statement and lie to you about why he had made that statement so that you would not believe it.
Could be.
Now, Doctor, you first met this defendant on September 23rd, 1991?
Yes.
Now that's, you agree, more than 2 years after the murder.
Yes.
And after he consulted with a lawyer in Tucson, Arizona,
Presumably so.
and after he'd been incarcerated in county jail for over 2 years,
Yes.
and after he'd been represented by yet another lawyer in Los Angeles for that period of time,
Yes.
and after he'd observed the preliminary hearing in this matter. Oh, you don't know about that. Okay. Wouldn't you agree that a defendant, can you assume, Doctor, based on your experience, that during those 2 years, there were events that the defendant witnessed in court that preceded this trial?
Yes.
And that during some of those events, he may have gained some knowledge of the prosecution's theory of the case?
Yes.
Wouldn't you agree that a defendant can absorb many suggestions about how to defend his case from all of those events that I've just described?
Yes,
And you saw him for the first time after all those events.
that's right.
In spite of all that, you still found reason to believe the statements that he made to you concerning the events that transpired on July 18th, 1989.
Yes,
Now, in previous cases, Doctor, you've testified that you felt the defendant deliberately lied to benefit his defense, specifically in ways that would lend support to a psychiatric diagnosis that would refute his sanity or ability to premeditate. Isn't that correct? Like in Hinckley?
We're going to do his trial next, and we're going to talk about it. Because I didn't. I was glad that he was found not guilty. But at the same time, he shouldn't have had a gun. It was self-defense. But why was he there with a gun in the first place? If he'd not been there with basically an illegal gun because he was too young to have a gun, it wouldn't have happened in the first place. Yeah. So he put himself in that situation where he had to defend himself. So it's like, to me, it's like a catch-22. But we'll talk about it when we do his trial. We're going to do that one next. Y'all, I've had this shirt. Squirrel, but I have had this shirt for decades. Well, yeah, at least 25 years. I just discovered that it glows in the dark. I was like, oh my God, my shirt is glowing. It glows in the dark.
And Shawcross?
yes,
And in fact, in both those cases, didn't you also intimate that defense psychiatrists may have coached the defendant into behaving or answering questions in ways that would favor his defense?
yes,
And in the article that you wrote for the Academy of Political Social Sciences in 1985, sir, didn't you also imply that that same kind of coaching could occur through the defendant's interviews with his attorney, cellmates, other people who visit him in the jail?
yes,
So there are many possible sources that might assist the defendant in preparing a false statement.
that's right.
Now, wouldn't you agree, doctor, that when a defendant gives you a self-serving statement, you should always look for ways to corroborate it before you rely on it in framing your opinion? Wouldn't you agree with that?
Yes,
And doesn't that go double for a defendant who has admittedly lied to all the authorities who have previously spoken to him, like this defendant has?
yes,
And doesn't that even go triple for a defendant who has seen all the evidence and the prosecution's theory of the case and been in jail for over 2 years before you ever saw him?
Again, I would object to that. That's a conclusion that's not supported in the evidence that Robert Bardo ever looked at all of the evidence, ever considered any of the emotions, ever considered or read the police reports.
Well,
Let me rephrase
as far
it.
as the police reports are concerned, there is no evidence, but if he was present during a legal motion in which a theory is set forth, I'm not going to assume he heard it or understood it or even listened, but it's admissible
Yes, but the
to
question,
show that he had the opportunity to listen, understand.
I agree, but that wasn't the question. The question was, assume that he was familiar with all of the evidence, familiar with the defense motions, and that simply isn't true, so I'm objecting on that
I
ground.
don't think I said all of that, but I'll rephrase.
I'm limiting it to the things that he was present, obviously, during, including the 995 motion And I don't know what the other motions were. I presume there was a lot talked about regarding extradition and failure to undergo the extradition process,
Yes.
etc.
And privilege.
Yeah. And all that sort of thing. Would you please ask the question again and delete those things as to which there is no evidence or things I couldn't take judicial notice that he was present during or observed?
Wouldn't that go triple, sir, for a defendant who has seen the evidence presented at the preliminary hearing and attended motions presented in court concerning the prosecution's theory of the case?
I don't know about triple, but it's still true there.
Right, now in this case, sir, you indicate that you do believe the defendant's statement that he was filled with joy after he had the first encounter with Rebecca Schaeffer because of her friendliness, correct?
Yes.
Is it also your position, sir, that at the time that he first approached her door on the morning of July 18th, that his intention was to have a pleasant encounter?
The first
When you
time
first-
he went? No, I don't think it was.
Wouldn't you agree, sir, that the first time he approached her door, it was for the purpose of killing her?
I think he expected that that would happen, yes, and that probably was his purpose.
Okay. Perhaps, I notice hesitation on your part, and perhaps I've overstated your position. Let me see if I can state it more clearly. Is it your position, doctor, that he was going to go to her door the first time and give her an opportunity to interact with him, and if she was arrogant, shoot her?
I suppose the most precisely I could put it is that he wasn't sure that she would be there, though he came to believe she really lived there, and that his expectation was to talk to her through the intercom. I don't think he even expected to see her, but he expected that if he did see her, she'd be arrogant, and he expected that if she was arrogant, he'd shoot her, because he'd rehearsed that in fantasy.
So in your opinion, doctor, when he went to her door, strike that, let me back up. Let me ask you this. In your opinion, doctor, when he came to Los Angeles, is it your opinion that he came to Los Angeles for the dual purpose of meeting her and perhaps not killing her, or meeting her and finding her to be arrogant and killing her?
There's a series of contingencies. He thought he had a better chance of finding her now that he had the address. And he thought he had reason to believe she'd be back from Rome because of what Triad had told him by telephone. So he expected that he might find her this time, unlike his earlier efforts. But he wasn't sure of that. And so there was the expectation that he might find her, and that if he did find her, she'd be arrogant. And if she were arrogant, then he'd probably kill her.
So in your opinion, doctor, he had left room for the possibility that she would be nice, and so not kill her. Is that correct?
Yes, I think that's right.
All right. So when he came here from Tucson, it may have been a slim hope, but there was some hope that she was going to be nice to him and would not force him to shoot her, correct? Not correct?
Well, it's a long trip, and I don't know that he had singularity of purpose the whole time. But I don't think there was certainty in his mind of what would happen. And that there was a predominance of the view that if he found her, he'd kill her.
That was the predominant view at the time he came here from Tucson, but in fact, there was going to be some opportunity that he gave her not to be shot. Is that your opinion, sir, of the state of mind of the defendant when he came here from Tucson?
She might not even be there. He might fail again to find her.
Assuming that he found her. But assuming that he found her, is it your opinion that the defendant came here with the frame of mind that he would give her an opportunity to be nice and so not shoot her.
No, not really. I think he thought if he met her, she'd be arrogant because he'd thought that so long and that he'd kill her.
All right. So it's your opinion that he intended to come here from Tucson to find her, to meet her, and then once he met her, she would do something, some kind of action on her part would justify him in killing her.
I don't know about justify, but
In his mind, I
he
mean.
would do it.
I don't mean that in the objective sense. I meant that there would be some action she took that would trigger that response in him.
That would trigger it, yes.
All right. In other words, he was expecting to have some interaction with her before shooting her.
Yes.
Have you reviewed the statement the defendant gave to the Los Angeles Police Department, sir?
At one point I did, yes.
In that report, sir, isn't it true that the defendant told the detectives that it was his intent to come to Los Angeles and shoot Rebecca Schaeffer as she either walked in or out of her apartment?
Yes.
All right. Wouldn't you agree, doctor, that that statement tends to conflict with the impression that you got from talking to the defendant concerning what his expectations were when he came here from Tucson on that morning?
Yes.
All right. And isn't it true that the defendant told you in his interview that with respect to the statement to the Los Angeles police, he tried to be as truthful as he could, with the exception of the two statements he made concerning the shooting being an accident and the location of where he disposed of the gun?
I don't know. I know he said that those things weren't fully disclosed to them.
As I recall, sir, in the videotape, and I believe it's the first videotape, the defendant made a statement to the effect that he had told them, tried to say all that he could with those two notable exceptions. And he did not say with those two notable exceptions, but he did say he tried to say all that he could to the Los Angeles police. Given that statement then, sir, by inference, we can at least deduce that the defendant is saying that that statement he gave concerning an intent to ambush her was the truth.
Well, by logic, but of course this is 2 years later and I don't know if he ever saw a copy of it.
His interview with you.
To the use of term intent to ambush.
Well,
That's conclusionary, but when she read the statement or summarized the statement to the doctor, she did leave out a critical word. The way this reads, and I have no idea whether this is an accurate transcription or not, when I went to Rebecca's, I planned to wait for her and shoot her as she came or went in. She left out the word wait. But I agree that wait is not equivalent to ambush, so I will sustain the objection.
Thank you, Your Honor. Let me reread the statement, Doctor, so that I can be completely accurate. I planned to wait for her and shoot her as she came out or went in. That statement, Doctor, does not appear to allow for any interaction, does it?
No.
All right, Doctor, if in fact that was the truth about what he intended to do when he initially came here from Tucson, then he would have lied to you when he said that he was going to give her an opportunity to interact with him, correct?
Well, he didn't say that to me in so many words. You'd asked me before what I thought, and I told you. But he told me what he was thinking and doing when he was around Sweetser Street that morning. And he told me that he had intended to harm her. He didn't tell me what he thought about on the bus trip or what his intent was there. I inferred that based on his having earlier intended to find her and shoot her, and his having that morning, as he was in the neighborhood, expected to find her and to shoot her.
Well, then let me ask you this, Doctor. Did you ask him, as he came out on the bus from Tucson, how he was planning to kill her? Did you ask him that?
No, I didn't.
Did you ask him whether he intended to kill her immediately upon finding her as he came to Los Angeles that morning?
No, because I talked to him about what he was thinking that morning.
Did you ask him what his thoughts were on the bus from Tucson?
No,
Did you ask him whether he planned to take her by surprise?
no,
At the time you interviewed him, you knew that that was the essence of what he was charged with, did you not?
I knew about the lying in wait allegation.
When you testified here that you felt that you believed the defendant when he said that the reason he did not kill her on the first visit was due to the fact that the encounter was a pleasant one. You made a few assumptions about the conditions prevailing at that visit, did you not?
I'm sure I did.
Okay, let me point out a couple, I'll be more precise. Did you not assume, sir, that the door was open enough for the defendant to have a clear shot?
Wouldn't need to be open at all to have a clear shot at that range. It's
But-
glass.
It is glass, sir, but if someone wanted to have an unobstructed shot, that is not to shoot through the door, you are assuming that the door was open and that such a clear range did exist, are you not?
I'm assuming the door was open enough for him to shake her hand, that she did open the door to him.
Are you also assuming then, sir, that she would be off guard enough to be vulnerable to an attack at that time?
Based on his account that she came to the door and believing that that happened, yes, that's vulnerable to an attack.
In other words, you're basing your perception that the defendant was truthful with you about the nature of that visit on his account of the conditions at the time, correct?
Well, I'm basing my belief about his account on quite a few things, but on those specific points you just mentioned about having a shot at her and her being vulnerable, that relies only on the truthfulness of his account that she really came to the door at all.
All right. And are you also relying, let me ask it a different way. If at the first visit, Rebecca Schaeffer never did more than crack the door open and behaved very cautiously, that this defendant, who admittedly was himself caught off guard, might possibly have felt that he could not move quickly enough to be sure of killing her the first time. Isn't that possible? Is that a possible explanation for why he didn't kill her the first time?
It's possible, but I think he knew enough about that weapon and ammunition to know it would readily penetrate the glass.
On what do you base that assertion?
The fact that he chose hydroshock at all, that a 357 hydroshock will penetrate multiple layers of 1/8-inch steel and has no problem penetrating a glass door.
So the fact that he chose that particular form of ammunition that is so lethal lends further support to the belief that when he brought it with the intent of killing, not a target practice. You would agree?
Well, there are two sides to the hollow point story. The other side is one that I didn't discuss with him as to whether he had any concern about bystanders being harmed through over-penetration, whether he had any concern about bystanders harmed through ricochet. And that's the reason the police use that particular round.
Because it tends to stay in the body, it penetrates.
It expands without over-penetration, without as much ricochet potential.
But you did not explore that possibility with the defendant as to why he bought that particular brand.
That's right.
So that to the best of your knowledge, the reason he bought that particular brand was for stopping power. You don't know.
Or just quality, I don't know.
Do you have any Did you ask the defendant whether or not he believed that the gun, if fired through the door, would penetrate a person standing behind the door?
No, I didn't discuss it with him.
It is possible then, doctor, is it not, that he felt his chances of a successful kill would be hampered if the door were closed and he shot through it? That's possible.
It's possible.
Now, let me repeat the question then. If at the first visit Rebecca Schaeffer never did more than crack the door open slightly, she was acting very cautiously according to his statement, and that he was caught off guard, one plausible explanation for his failure to kill her at that time might possibly be that he was simply unprepared at the moment. Correct?
That's possible.
That the conditions were simply not optimum enough for him at that moment to feel sure of success. Is that a possible reason?
Yes.
Have you compared the statements that he gave to the police shortly after the murder with his letter to Robert Cleves, written 2 years after the murder?
Only on some points.
Okay. Let me point out one specific point. You're aware that the defendant's description of that first visit differed in the following respect, initially anyway. He told the police that during that first visit, she was moving the door like this, and on the film, I think on one of the videotapes, he indicates what like this is, and it seems it's kind of a cautious moving forward and back motion. Do you recall that?
I recall something like that. It was hard to tell what that gesture was because he was chained to the chair when I interviewed him. His left arm was immobilized.
Okay. There was some motion, though, that he was trying to indicate she was making with the door.
Yes.
Yes. In his statement to the police, he never indicated, and I mean either Tucson or Los Angeles, sir, he never indicated that at that first visit, she stepped out onto the porch and confronted him full face with the door wide open.
That's right.
However, in the statement that he made to Robert Cleves 2 years later, he did make a very definite point of indicating that in that first visit, she came almost all the way out the door and stepped out to the porch, didn't he?
Yes, I think he did.
Now, there is a discrepancy there, isn't there?
Yes.
Okay. Did you ask the defendant to explain that discrepancy to you?
No.
So there might be, just from that one point, some cause to doubt whether the defendant ever felt he could get clear enough access to successfully kill her at that first visit. Is there not? That's one indication.
I missed the import of your question. I'm sorry.
It's getting late. The fact that there is a discrepancy concerning Rebecca Schaeffer's position at the doorway, i.e., to the police, it sounds like it's more protected and back into the apartment. To Robert Cleves, it sounds like that she's standing right out there in front of him with the door wide open. I'm exaggerating a bit, but you understand what I'm getting at?
Yes.
By that large discrepancy, would you not agree that there's some cause to believe, just based on that discrepancy alone, that the defendant might have felt that, first of all, let me break it down. The first statement might be the truer statement about what really transpired at the first visit, might it not?
Yes, it could be.
All right. Given that state of affairs, might one not deduce from that that he did not feel confident enough to get a clear shot at her, given those circumstances?
That's a possibility.
Okay. Now, the defendant, there's something else to consider about that first visit. The defendant told you that he left one chamber open so that as a safety measure, so he would not shoot himself in the foot. Do you recall that?
One chamber empty, yes.
Yes, I'm sorry, empty. And didn't he say also to you, as you remarked earlier, that he expected to talk to her on the intercom and not see her in person?
Yes.
And that he was caught off guard when she actually came out to the door on that first visit, correct?
It surprised him.
Yes. And now put all of that together with the statement that he gave to Los Angeles police that he expected to wait outside and shoot her as she came in or went out of her apartment. Consider all of that, doctor. Now, at the point when he first went to her door, he had already been at the neighborhood for 2 hours, correct? At least.
He'd been there for some time.
Well, he stated, I believe, that he got there at about 6:30, and we have a witness who saw him there at 6:45. You're aware of that?
Yes.
All right. And by the time he spoke to his sister at 8:30, he had still not gone to the door. Isn't that correct?
Yes.
And he hung up with his sister at roughly 9 o'clock, and he had still not gone to the door, correct?
Right.
So we have perhaps 2.5 hours of waiting before he actually goes to the door the first time. Is that a fair assessment?
2.5 hours in the neighborhood.
Yes. Now, after that length of time, if indeed it was true that what the defendant planned to do was wait outside for Rebecca Schaeffer to either come in or go out, after 2.5 hours, we may infer that he felt that plan might not work. Is that fair?
That's possible.
Okay. And in fact, at the moment that he makes the phone call to his sister, I believe the phone bill said it was 8:40. So he's already been in the neighborhood 2 hours. At that point, sir, having not seen Rebecca Schaeffer either come in or go out of her apartment, he may have been suffering from a case of flagging nerves. Isn't that plausible?
When he called his sister,
Yes.
that could be.
All right. And didn't he say to his sister, I'm going to quote from the videotape. Tell me if this matches with your memory, sir. He said to his sister, quote, I wasn't sure I could do it. I could fantasize about violence, but then it's kind of different to actually do violence, you know. I guess there's a thing called moment of truth where you act, you know, and I didn't feel that I had the nerve yet, end quote. Does that sound familiar to you?
Yes, it does.
Now, given all of that, did you ever ask the defendant whether the real reason he failed to kill Rebecca Schaeffer at the first visit was due to the fact that he simply had not yet fully psyched himself up and felt that, physically speaking, the conditions were simply not optimum, given the fact that Rebecca Schaeffer behaved cautiously, the fact that he'd left that one chamber empty, and the fact that he was caught by surprise, that he realized he could not move quickly enough to pull the gun and pull the trigger twice before she'd escape?
Well, first of all, it wouldn't have been necessary to pull the trigger twice because the empty chamber cycles out of way and a loaded chamber into position with the first retraction of the trigger.
Doctor,
But you're-
didn't know that, did he?
He didn't know which direction it cycled.
You asked him if he knew whether the chamber would rotate prior to firing or after firing?
I asked him if he knew which direction.
But you didn't ask him any more detail about how that chamber rotates, did you?
No, but I did ask him about why he left one empty and where he left it empty.
And his answer, as I recall, was that he didn't know whether the chamber rotated to the right or to the left when it fired. Is that correct?
Well, his first answer was that he understood that the one right under the hammer is the one that could be struck if the hammer were accidentally struck.
Okay.
That's why he left that one empty.
Right. And he also said he didn't know which way it rotated when it fired.
That's right.
Okay.
So that this defendant may have been thinking, although it would be wrong, this defendant may have been thinking that if he decided to pull the gun at that moment, he would have to drop the hammer twice to fire a bullet, correct?
It's possible.
He was certainly not an expert in firearms at the time, to the best of your knowledge, was he, sir?
No, he only knew what he could learn from movies, and they're often misleading.
So then wouldn't you agree, sir, that the scenario that I have just painted for you is also a plausible explanation for why he did not kill her the first time?
It's a plausible explanation, yes.
All right. And that plausible explanation takes into account the physical evidence, that is, that he was, by his own statements, physically not prepared to commit the act, as well as the mental unpreparedness that he evinces in his phone call to Arlene, correct? Or to put it, I suppose, more succinctly, the defendant's failure to shoot at the first opportunity simply proved his ability to control his actions and await a more favorable situation.
That's possible.
All right. Now let's talk about the defendant's own description of the first visit, Doctor. If you really listen to how the defendant described that encounter, I want to point out a few things and see what you think. As I recall it, he mentioned that she told him not to come back to her front door. Do you recall that?
Yes.
That's not a particularly friendly statement, is it?
No.
Okay. Correct me if I'm wrong, Doctor, but it seems to me that I also heard him say on the videotape that she kind of gave him a cold look on that first visit. Do you recall that?
Yes.
That's not particularly friendly, is it?
No.
He also indicated that she seemed in a hurry to get back inside. Do you recall that, Doctor?
Yes.
That's not particularly friendly either, is it?
No.
Yeah. And he also indicated that she was behaving cautiously. In the Tucson and Los Angeles statements, he indicated the movements with the door, but I believe he said that to you as well, did he not?
Yes.
That's not necessarily unfriendly, but it's certainly not warm, is it?
Correct.
So in fact, there is some evidence that would tend to contradict the defendant's assertion that the first encounter was such a pleasant one. Is that true?
Well, his statements,
Okay.
but of course he makes many other statements too.
Absolutely true. But even within his own statements concerning the characterization of that first encounter, one may deduce from his own words that it was not as pleasant as he has tried to make it sound to you. Is that fair assessment? Is that true?
Well, I think the truth is this, that yes, there were those things that are less than the reception he might have liked, but more important than all that was that he actually...
Well, I was gonna say, you know, in dry weather, your lips get dried. I mean, in cold weather, your lips get dried out. Well, no, that's not it. I was gonna say, but it doesn't get cold in LA. But he's not from LA. He's from Arizona. It gets cold enough where I live for my lips to get all chapped and dried, though. And I'm in Florida. Never mind. I don't know what I'm talking about. See, I'm not ignoring you, Marty. I'm only partially ignoring you. I'm not ignoring you. I'm multitasking. That's it. I'm multitasking.
actually met her. He actually saw her face to face. He actually shook her hand. And she was a normal seeming person, not a larger than life figure, not someone in a palace or in some glamorous setting, but a down-to-earth, ordinary human being who looked more like a college student. That was shocking to him. That was more shocking to him than any of the rest of this, because he had this over-idealized conception of her, much larger than life. And to find her more like someone that he actually could know, could talk to, was astounding to him. That's what was foremost in his mind. And to have actually met her was a triumph. It was his greatest achievement in life, to see her face to face and shake her hand.
Doctor, in that same meeting, didn't she say, "I'd rather you not come to my door"?
Yes.
He remembered that, didn't he?
Yes.
And he carried it with him during the half hour or so between the first and second visit, did he not?
Yes.
And he knew that she didn't want him to come to the door, didn't he?
Yes.
Now, isn't this a hypersensitive individual who is very sensitive to rejection or arrogance?
Yes.
As a matter of fact, what she said to him on that first visit isn't much different from what she said on the second visit, is it? Which was, according to your theory of the case, the trigger for killing her.
What she said was not so different. How she said it, he described differently. How he perceived it, he described differently.
Did you ask him if he had any trepidation about returning to her door the second time after she had told him she didn't like that?
No.
Didn't he tell you that between the first and the second visit, he put a live shell in the remaining chamber?
Yes.
Do you have any theory as to why, of all the moments
Not
that
on
he
YouTube right
spent near 120 Switzer, he chose that particular moment between the two visits to fully load the weapon?
Only two, Your Honor.
What are they?
One is what he said, which is that he did that at a time when he was preparing to return to the bus station to go back to Tucson and share the good news with his brother Ed, since he saw the bus station as the high-risk area. The other is the prospect that he loaded fully at that time to return to Rebecca Schaeffer's and kill her.
All right. And wasn't he, according to your theory, obsessed with going back to see her one more time? Wouldn't being mugged at the bus station be the furthest thing from his mind?
I think Rebecca Schaeffer would be fully on his mind. And he describes deliberating whether to go back or not. He told me that decision-making process.
But in the meantime, he takes time to be worried about whether or not he's going to be mugged at the bus station. So for that purpose, he loads the weapon?
Well, he said he was contemplating going back to Tucson, was preparing to make the trip, went into the men's room and did this, after which he continued to deliberate whether to return to Miss Schaeffer's.
No, you're talking about going into the men's room at the bus station. I'm talking, didn't he say that he went into the alley and put the other shell in, or am I wrong?
You're wrong, Your Honor.
All right. No, please correct me.
It was that last round, he told me, he loaded in the men's room of the diner.
All right. And he also made a statement that he put the last shell in a letter to Mr. Cleves between the two visits. Isn't that correct?
I don't recall.
Do we have the letter?
Yes,
Did I see it?
yes.
43 or 44, one of the two. All right. On page 4 of the letter, he gives the story about not wanting to be robbed. And then he said, this time I would not get robbed, so I filled the empty hole in the gun barrel. Then he says, so I went to Rebecca's home, like I said. I didn't trip. I rang the doorbell again. Would that imply that he admitted to Mr. Cleves that he loaded the gun between the two visits?
I haven't found the same letter, Your Honor, because there's several.
Here, I'll give you the original.
Yes, it does.
Yeah, page 4.
Thank you. Yes, it does imply that.
All right. We need to take a break. Is there anything that you want to ask before we do?
No, Your Honor, I won't be able to complete today's.
All right. All right. We'll be in recess until 10:30 tomorrow morning.
I believe my crop should be done by noon.
I have a theory about the reptile eye things, but it also could be Photoshop. But I have artificial lenses in my eyes because I had cataracts, and when the light hits it just right, my eyes look funny. That could be what we're seeing. Although I doubt all these people that we see in these videos have got artificial lenses. But I mean, most of these people are rich celebrities that we see on these videos, right? So you can have corrective lenses implanted into your eyes, because I could have done that when I had my cataract surgery. I could have got prescription lenses put in my eyes. So who knows? Maybe like these rich people have had prescription lenses put in their eyes so they don't have to wear glasses. And that could be what we're seeing on all these videos where they say they're alien people, because pretty soon, yeah, pretty soon I'm going to be like the bionic woman. And my stepdaughter took me to one of the surgeries. And the other day we were at the movies. Well, not the other day, but the last time we went to the movies, we were standing there and she looked at me and she goes, "What is in your eye?" And I said, "What are you talking about? You've got something in your eye. That's weird. What is it doing?" And I said, "Oh, that's the artificial lens. And it does that sometimes." And she goes, "Oh, that's weird." I know. Wiggles hates it when I'm logical. I'm just saying that could be one explanation. Could be. Or it could be lizard people.
Just go ahead.
Thank you, Your Honor. Good morning, Doctor. Good morning. When we left off yesterday, we had discussed some of the negative aspects to the first visit. And although you agree that there were some that we had pointed out, you believed the defendant when he said that it was a pleasant encounter. Is that correct?
Yes.
Did you ever point out to the defendant the rather negative, contradictory aspects that we discussed yesterday?
I don't think so.
Did you consider those contradictions in concluding that you believed the defendant when he told you it was a pleasant visit?
Yes.
Did you also consider the fact that his story about that first visit changed from the time he spoke to the police to the time he spoke to you 2 years later? And I'm referring specifically now to the point that he made in his statement to you about her stepping out in front of him on the porch at that first visit, whereas when he spoke to the police, he did not say that.
I don't think it was that dramatic a change.
Is your answer then no, you did not consider that?
I didn't consider that there was any substantial change about what transpired during the visit. He gave me more detail than he'd given the police, and he put a different twist on it.
Well, a different twist. Do you consider the fact that he told the police it was an accident and told you he did it on purpose a different twist?
He didn't tell the police it was an accident in the second statement. He gave the impression to the police in the first statement in Tucson that it was an accident, and I think he even used that word. In the second statement, he told the story in a way that that's what one might infer, or at least that's what the police recorded, their interpretation of what he said. And what he told me was consistent even with that second statement and time sequence.
Let me interrupt again. I may seem a little dense, but as I understand it, there are transcripts of both interviews.
There is a statement, handwritten statement by LAPD, and there's a transcript of the Tucson.
That's the one I referred to yesterday.
Yes.
And the transcript is of Tucson.
Correct.
There is no transcript of LAPD.
Correct.
Okay. LAPD was not recorded?
Correct.
Okay. And we had mentioned the fact that you wanted me to read that.
Yes.
The transcript of the Tucson police. I still don't have it.
I can address that issue, Your Honor. I have a copy of the transcript and I have a copy of the audio tape, which I intend to mark as a defense exhibit. I do want the record to be clear, and I think it is clear, but perhaps it should be restated. Our stipulation as far as the introduction of the alleged statements by Mr. Bardo, I think it's always been understood that was a paraphrasing by the police officers.
Police reports always are paraphrasing unless they put quotes around what they write, and then I would presume that it would be a direct quote.
And it is absolutely clear that they did not record the interview. did not have a stenographer.
Well, that was always clear. The only thing that is not clear to me is why I don't have the transcript, because it possibly would be helpful to me in understanding this testimony.
In that, let me do this, Your Honor. I have a copy of the transcript now. However, this one has been highlighted. I prefer not to mark this one as an exhibit, but if the court would like.
Well, I certainly don't need an original. All I need is something that is accurate.
May we approach?
Sure.
What I would propose to do is give you this, but then replace it with another one that isn't highlighted. In other words, I highlighted that. I don't have the other copy with me. But if you want to.
Don't you have a copy?
I gave him, yes, he's got a couple of them now.
Oh, and you have one.
So I can bring you.
Oh my God, dude.
I'm not telling you people what to introduce or when. That's still-
No, I know, Steve had asked me to bring it down to give to you, and I thought I had, and I did, and I brought it down, and then,
So if it's
I thought it
okay,
was
we will
good.
let him look at this, and then
Sure.
I'll replace the one without the highlights. I don't think he's going to be.
All right, fine. Good. As long as we're talking about transcripts, we have, as you know, I have made a ruling, and you both have stipulated this correct ruling to the effect that all the statements made by Mr. Bardo to the psychiatrist, to the police, are not admissible for the truth of the things stated therein, but merely to serve as a basis for the psychiatrist's opinion and for any relevance they may have on the defendant's state of mind. Is that correct?
That's correct, and it's even further as far as I'm concerned, Your Honor. There was never, ever any stipulation as to the accuracy or authenticity or the reliability of the statements purportedly made by Mr. Bardo as reflected by the Los Angeles Police Department officers.
Well, yes, and also there is no stipulation that the statements made by the defendant on the videotape are accurate reflections of what occurred. I'm understanding all that.
if the defense had some qualms about the veracity of or the accuracy of the transcription done by the Los Angeles Police Department as to whether or not it was a faithful rendition of what the defendant said, then I have failed to hear any testimony or any arguments pertaining to that point. And I had assumed that in light of the lack of such an attack, that it was pretty well understood it was an accurate rendition of what was said to them at the time.
Well,
I've never, ever indicated that I believed that what the officers wrote down was accurate or that they were not biased in the way that they wrote the report. And that was clear, and I don't think that it's fair to assume that a lack of stating all of the qualms and questions I have concerning the activities of the Los Angeles Police Department means that that's a acquiescence to any facet of their testimony or reports.
I am aware of all the possible biases of all the people who may have seen or heard something in this case, and I will evaluate the evidence based on the content, how it relates to all the other evidence. I am not taking anything as God-givenly accurate. I'm going to analyze everything, and I have been analyzing things. So the only thing I was leading up to is there is one thing that was said by the defendant that is hearsay, but I will take for the truth of the matter asserted, and I think it's something that neither side is contesting. There's a Supreme Court of the United States case that has to do with hearsay, and I haven't had time to look it up to give you the citation, but I'm sure both counsel will be aware of it when I tell you what the holding is, and that holds that it is unconstitutional to not admit hearsay that is is certainly accurate, that the surrounding circumstances show accuracy. And what I'm talking about is the fact of a first visit by Mr. Bardo. I think that's indisputable, and I'm taking the statements that such a visit occurred as fact. The reason for that is the accurate description of the clothing she was wearing, which was described not only by him, but also was verified by the clothing in the bathroom, including the glasses which were in the bathroom. The only other possible interpretation is that the defendant, while standing outside, saw her come out for some other purpose without a confrontation. And I've seen no evidence to that effect at all. In fact, I see it as somewhat unlikely, considering the time of day and the fact that she hadn't showered yet, etc. It's a possibility, but is there any objection to that from either side?
No, Your Honor, but I would
But I'm, of course, not taking for the truth of the matter stated anything that the defendant says occurred during that meeting. That is a matter that is subject to dispute and is only up to, it's only a basis for the opinion of the psychiatrist insofar as it reflects the defendant's state of mind.
I would appreciate it, though, Your Honor, if defense counsel has some specific problem or contention concerning the veracity of the rendition given by the Los Angeles Police Department in that report, then I think that ought to be presented. It has not been presented. And so, I mean, the counsel might have an underlying philosophy concerning the accuracy of police reports, I think, is not a sufficient basis on which to impeach the rendition that was given by Los Angeles Police Department. So if there is some specific attack, I'd like to hear about it.
Well, that's fine, but I think counsel is free to argue what he believes the report reflects. Let me say this, Mr. Galindo, that it does appear to be a remarkably detailed statement. And again, I believe it's page 8 that has the statement. I was holding a gun in the bag with my right hand and I reached down to get the right letter. She saw the gun and started to scream. She tried to close the door and I felt a bump on my left arm. That statement is so detailed that I don't see any reasonable possibility at this point, and I haven't read the transcript of the Tucson report, I don't see any reasonable possibility that that statement could not be accurate in its main details absent an outright lie by the police officers.
But the court is, again, taking one statement out of context. My point
Well, that's all I have before me, as I've pointed out, regarding this particular segment of time. And I will read it in connection with the transcript, which I now have, of the Tucson police interview and make my own decision. But I'm just telling you what my feelings are just from having seen one statement.
I understand. May I respond briefly, Your Honor? My only point is this, is that we know that the Los Angeles Police Department officers have written that report, that they are not indicating that's a verbatim report. They are not indicating that those were the words of Mr. Bardo. We know that they did not tape record the statement. We know that this is their paraphrasing and their writing of the report. We all know how police officers write their reports. All I'm indicating is that I've never stipulated that this was accurate or did not reflect the bias which I believe exists in the members of the Los Angeles Police Department in writing that report. That's what I'm indicating. And I've never stated that I believe that they were not biased or that it was totally accurate or that they were
You're
totally
free to argue the inaccuracy, to compare this statement with the statement made to the Tucson police and any other statements the defendant made or was alleged to have made. But let me tell you that my initial impressions from reading this statement, and that includes all of them, their use of the word I would indicate to me that there was an attempt to come as close as possible to getting down, if not verbatim, very close to verbatim. And if it's hard for me to figure how a little slanting of what he said would come up with, he was bumped on the arm with a door and the gun went off.
I'm not indicating that any one line is inaccurate. What I'm indicating is that taken as a whole, and the whole statement and taken as a whole, the entire way that the statement was reflected by not being tape recorded.
All right, you're free to argue that, but it's premature. All right, let's proceed.
Doctor, looking at the Tucson transcript, do you see any mention when he discusses the first visit in that transcript of the fact that she came out onto the door, out of the door and onto the porch to talk to him?
I haven't yet, no.
Did you see any mention of that fact in the statement taken by the police department in Los Angeles?
No.
To the extent that that statement that he gave to you 2 years after the event is not apparent in his statement to the Tucson police officers or the Los Angeles police officers, there is some apparent inconsistency, is there not?
I'm afraid I don't see it, since the absence of a mention of it doesn't address the issue. And the physical evidence is consistent with what he told me.
Excuse me, what physical evidence are you talking about?
It's my understanding that the victim's feet were propping the door open.
You're talking about the second visit, doctor. I'm talking about the first visit.
Oh, I thought we were talking about the second.
No, the first visit. When the defendant discussed the first visit with both police agencies, there was no mention made of her coming out onto the porch to speak with him. In fact, in his statement to Tucson police, he made some indication that she was moving the door like this, and I agree, we don't know what that was, and acting very cautiously. In his statement to you 2 years later, he said, and in his statement, I might add, 2 years later to Robert Cleves, he said she came almost all the way out the door, and he made a point of doing that in the letter at least. Wouldn't you agree that there is an apparent inconsistency between those two versions?
Well, I'd really like to compare both versions side by side, but if one says that she didn't come out and the other says she did, that's certainly a contradiction.
Did you see any mention in the police reports or in the transcript of his statement from Tucson about her coming out onto the porch at the first visit?
No.
That only appeared in his statement to you and his letter to Robert Cleves 2 years later. Correct?
I don't know. I don't recall his saying that to me or seeing it in the Cleves letter. I'd like to look at it. It's not that I'm disputing it. I just don't recall.
Let me show you the Cleves letter that I'm referring to. And I'm showing you the original that has been marked as People's 44. And it's a lengthy letter, so I'm going to turn to the page.
Travis is like that, drives me crazy.
Page 2 begins. I'll let you read to yourself.
I've read it. I still don't see anything about coming out onto the porch. I do see.
Judy, there are some restaurants that I can never go to again, ever. Because Travis got either bad service or a bad meal there. I'm like, it happened one time. It was a fluke. I can never eat there again. It drives me nuts.
The reference to what he said earlier about her being cautious, opening the door a bit, opening it more, opening it all the way.
Okay, let me read it out loud, doctor. She opened the door. She said, yes. I introduced myself. I said, I'm Robert Bardo from Tucson, Arizona, and I'm a fan of yours. I'm sorry to bother you. Then I went into my white grocery bag and pulled out the picture postcard she sent me. As I did this, she closed the door a little and looked into my bag to see if I was pulling out a weapon. I pulled out the card in a plastic sandwich bag and handed it to her. She came out more. I said, "Do you remember sending this to me?" Sweetly, she said, yeah, I do. She said it politely. Then I said again, "I'm sorry to bother you." She said as she came out almost all the way, "I'd rather you not come to my front door." I said, I'm sorry about that." Then she was almost out all the way. Now, there are 3 statements that appear in the lines that I've just read concerning her coming more and more and more out the door. Isn't that correct?
Well, out.
Yes, I believe,
Out.
I object. I believe that's a misstatement or her own characterization of what that says. The original question was that there were statements in the letters indicating she came out onto the porch. That clearly isn't what's reflected in the letters.
That clearly isn't what
It is not reflected in the passages that she just read.
well,
Basically, what I'm indicating is that the words speak for themselves.
well, they do, but I think she's allowed to cross-examine this witness on the significance of any contradiction or similarity in the 2 statements. And objections overruled.
Doctor, there are 3 statements there in which she obviously says that she is moving into a position that is closer to him and less behind the door. Would you agree with that?
That she is more exposed, yes, I would.
Would you also agree, Doctor, that in his statements to Los Angeles police and Tucson police, there is no mention made of her coming closer and closer to him or coming less and less, or more and more away from the door?
There's no mention of that either place.
Doctor, in the letter I just read, there are 3 statements made indicating what appears she came out more, she came out more, she came out more. Is that correct?
Yes.
Do you see that in either his statement to Tucson police or Los Angeles police?
No.
Did you consider the fact that the nature of that change would tend to make it more appear that he had, the nature of that change would tend to make it appear more like he had a clear shot and opportunity to kill her at the first visit than his earlier statement to the police did?
Not particularly, because he told the police that he wasn't prepared the first time.
Doctor, that's not what I'm asking you. I'm asking you with respect to just these statements. The import of the statements that we find in the letter to Robert Cleves, that we do not find in his statements to the police. Would you agree that the import of just those statements about her coming out more would tend to make it appear that he had a clearer opportunity to shoot her the first time?
I suppose so, if you assumed he couldn't shoot through the glass or was otherwise ready.
Now, wouldn't you agree, Doctor, that if the defendant admits that the first visit went badly, he is very hard pressed to give an innocent explanation as to why he went back the second time?
Would you repeat that, please?
Yes. Would you not agree that if the defendant admits that the first visit went badly, he is very hard pressed to give an innocent explanation as to why he went back the second time?
Not particularly,
Why not?
because this is a man who simultaneously loves and hates, who can switch in an instant from she must die, she's evil, she's all bad, to she's the best, she's the greatest, I love her.
Yet, Doctor, I find it very interesting. Did you notice that when he told you he went to see her in July of '87, that was the visit where he had come armed with a knife? And he said to you, I was still pissed off from the first time. And that was a month and a half earlier.
Yes.
It would appear that he could maintain the feeling of animosity for at least a month and a half, would it not, from that statement he made to you?
There's no doubt about it.
And then he indicated to you that in 1989, when he thought about Rebecca Schaeffer again, he said, I was still pissed off at her. I still had animosity for her, didn't he?
Yes.
And so that would indicate that not just over a matter of months, but over a matter of years, he could maintain the feeling of animosity, doesn't it?
Not continuously, of course, but certainly he'd maintain that.
Then, Doctor, what I'm asking you is, if he could maintain the feeling of animosity over a period of at least months, and he had a visit with her on the morning of July 18th that went badly, and returned, at least by his statement to some people, a half hour later, he could certainly have maintained that feeling of animosity over a half-hour period, could he not?
He could have, yes.
Then wouldn't you agree, Doctor, as a practical matter, if he admits that they did not have a pleasant encounter at the first visit, and yet he went back again the second time, he is hard-pressed to give an innocent explanation for doing so?
Well, first of all, he doesn't have to. Secondly,
What do you mean by he doesn't have to, Doctor?
this is America. He needn't. Secondly, there's
Remark will be stricken. We're trying to get at a man's state of mind, not what he has to do or does not have to do. The issue is what he did.
Yes, Your Honor. However, the question was put to Dr. Dietz in that fashion, in that specific.
She said he would be hard pressed to his explanation.
I believe she said he would have to. I believe was her term. But in any event,
I didn't take it as legal compulsion, which is apparently what the doctor's talking about. I took it as meaning that in order to justify his conduct, he would have to, in a credible fashion, he would have to do something. That's all I took it as.
Doctor, he did.
I agree the defendant does not have to speak if he doesn't want to. The fact is that he chose to speak.
Yes, exactly. He did choose to speak, did he not, Doctor, to offer an explanation to the police?
well, I'm going to object to that. I think the record is clear that the court has before it that he had, the officers had asked him about his wanting to have an attorney, and I believe that the report you have indicates at the beginning he told the officers he did, but that the officers went ahead and continued to elicit statements. So
yes, fully realizing that they would not be admissible on guilt, but the record, I suppose, to try to clarify what had occurred. As a matter of fact, the doctor has relied on these statements that were not admissible for the truth as admissions in formulating his opinion. So the record is clear that the defendant, when advised of his constitutional rights, chose to rely on those constitutional rights and not speak. And then the officers continued to question him. I see no evidence of any force exerted against him or anything like that, anything that would traditionally make these statements involuntary, other than the fact that he asked for a lawyer and they continued to question him. As a matter of fact, you stipulated that these are admissible as a basis for the psychiatrist's opinion, presumably because you feel that they can turn material that's favorable to your side of the case.
no, I stipulated because the doctor did rely on those statements, and therefore, under the law in California, he would be the district attorney would be entitled to cross-examine him and to be aware of the.
I'm really puzzled as to how he could possibly have relied upon them unless he had been furnished them.
No,
And I'm at a loss to see who would have furnished them other than yourself.
no, I agree.
Okay.
Well, wait a minute. The court has made some statements. I wanted to be clear. I did furnish everything to Dr. Dietz because I did not want to selectively hand him materials that were only favorable to the defense. I felt that the only way Dr. Dietz could do an honest examination was to consider all the evidence, damaging or otherwise. So that is why I furnished him
I
materials.
understand, Mr. Galindo, and I commend your honesty and competence in that regard, because I think things could be done. The point is that the defendant did offer an explanation, and the record is perfectly clear as to the conditions under which he did it. But at this point, since they are being considered for the for the as the basis for the doctor's opinion, I have to accept them as statements that were made. You can argue the accuracy with which they were transcribed or reported, etc. But the statements were made, and the defendant made them, as far as I can tell, at this point, voluntarily. All right.
Having chosen to give some explanation, Doctor, wouldn't you agree that if he represented that the first visit went badly, he would be very hard-pressed to come up with an innocent explanation for returning the second time?
Be very hard-pressed to come up with an innocent and rational explanation, yes.
So wouldn't you agree, Doctor, that he certainly does have some motive to lie about the nature of that first visit?
Yes.
Did you take that into account when you concluded that you believed him when he said that the first visit was friendly?
That I took into account, yes.
Well, you've stated that you think it's important to find independent corroboration for a defendant's statement, particularly one that is self-serving, made after the event. What independent evidence, by which I mean evidence that is not the defendant's post-arrest statement, did you find to corroborate his statement to you that the first visit was friendly?
There isn't any one way or the other, though I sought it by looking at what all the proximal witnesses had to say.
And you found none?
That's right.
Now, after the first visit, Doctor, the defendant then told you that he left. And he walked around and he considered whether to go back or not. And he said he was afraid that she'd bite his head off, afraid of being seen as a pesky little fan, but thought, let's get this over real quickly. Didn't you find it somewhat contradictory then when he told you he was going back the second time with the expectation of a pleasant visit?
Well, in the context of all I knew about him, it didn't surprise me. Nothing he might have said then would have.
In other words, even if he had told you at that point, she hated me, she threw me off the front porch, and I was furious with her, but when I went back, I decided, well, maybe things will be okay, and I was hoping for a pleasant visit, you would have believed that too.
I've seen it happen.
And you would have believed it had he told you that.
Would I believe that that were so? I don't know. It didn't happen that way.
I'm asking you if it had. Would you have believed him when he said he went back expecting a pleasant visit the second time?
What other assumption should I make?
The one I just gave you, that the first visit went badly. She threw him out. She said, don't ever come back. I don't want you on my front step. Get out. If he had told you that occurred on the first visit, would you still believe him when he said he went back the second time expecting a pleasant encounter?
If I assume everything else I know about Robert Bardo up to that time, no, I would not have believed that.
Now, the statements that I've just given you that were excerpted from his statement to you about being afraid she would bite his head off, being seen as a pesky little fan, and thinking to himself, let's get this over real quickly. Did any of those things occur to you to be contradictory to his assertion that he expected the second visit to go well?
The first two.
And did you ask him about that?
I asked him how he made his decision, and in fact used it as an occasion to try to look at his decision-making. And so I asked him to list the pros and cons of returning, which he did and which I testified to, I think, 6 days ago.
Did you ask him why he expected a pleasant visit the second time if he was afraid she would bite his head off and afraid of being seen as a pesky little fan? In other words,
Well, he told me
and what was it he told you?
that it had gone well before, and he expected it would go well again. He hadn't done it as well as he wanted before. He wanted to pay another visit.
I see.
He told me what he hoped.
So you believed him when he said he expected a pleasant visit the second time because you believed him when he said the first visit went well, correct?
And because I believe other things about him that are consistent with that.
I understand. You're talking about a general assessment of his personality. I'm talking about the statement. You believed that the first visit went well. Therefore, ergo, you also believed him when he expected a pleasant second visit, correct?
Well, I believed it went as well as he told me it did. which was not perfect, but was the best day of his life.
Fine. You believed him when he said the first visit went well, correct?
Precisely as well as he said it went.
He represented it to be a pleasant encounter to you, did he not, Doctor?
He represented positives and negatives about it, but on balance, it made him extremely joyous.
Which led you to conclude that he was telling you it was a pleasant encounter for him, correct?
That he was telling me, just as I've said, that he left there joyous and happy, and that on balance it had been a good occasion.
All right. And you have no independent evidence to corroborate his characterization of that first visit, correct?
That's correct.
And you agree that he certainly had a reason to lie about the nature of that first visit, given the fact that he went back the second time, correct?
Yes.
And you yourself have espoused the theory, have you not, that a defendant's post-arrest self-serving statements are not to be relied upon in the absence of independent corroborating evidence, if at all possible. Isn't that correct?
That's right.
And yet you did just that in this case, did you not?
Well, later there is some corroborative evidence, I think,
To the fact that there was a pleasant encounter at the first visit?
to the fact that on balance it was what he regarded as joyous. That isn't that it was not the nasty encounter that you described.
Tell me, what was that evidence, Doctor?
The fact that Rebecca Schaeffer came to the door again and opened it to him.
You mean the fact that he allowed her to live the first time?
No, the fact that she came a second time to the door and opened it.
Oh, I see. You're assuming, of course, that she could see him, aren't you?
I'm assuming that by the time she was at the door and unlocking it, that she knew that this was the same person, yes.
And you're also assuming that she went to the door seeing there was someone there, at least of the height that matched the defendant's, correct? If she could not see his features, at least she could see it was about the same size person she'd seen a half hour earlier, correct? You're assuming that.
That is misstating the evidence as far as what she could see. We did enter into a stipulation that indicated she had some problem with her eyesight at a distance of approximately 9 feet. But there was no evidence in the stipulation or otherwise which indicated that she would be unable to discern persons or objects at a close range,
That's
closer than 9 feet.
The stipulation involved, Your Honor, the fact that she would have a range of vision that was normal to it.
If you're standing right on the other side of someone's door, that's not 9 feet. What are they talking about? You can look, if there's a way for her to see, like a window or something on the door, and someone's standing right on the other side of the door and you are unlocking the door, that is not 9 feet.
Then I believe 7 or 8 feet, perhaps it's 9, and that she could discern objects at a distance, although not clearly defined features, at a distance of 70 feet. That was the entire stipulation.
Well, why don't you frame it in terms of hypothetical? If someone is approaching someone who is in a doorway that is backlit, even someone with normal vision would have a hard time distinguishing features. The evidence I've seen in the photographs indicate this was a glass doorway facing directly out into the street, so there would be incoming light from the back. I'm not saying that anybody has stipulated that she could or could not make out the features, but there is that possibility.
Well, whenever we speak in range of possibilities, then we could go ad infinitum as to all the different types of possibilities. But I would also
a reasonable possibility, Mr. Galindo. I have probably, in 58 years of life, approached thousands upon thousands of doors that led to the outside, including a childhood in New York where that was living in apartment houses where that was the typical way that you would walk out, and if somebody was standing in front of a glass door, which in those days was typical because crime was low, you would see outlines of people and you would identify them from their general configuration. Then, depending on what the lighting was inside, sometimes you could see some features, sometimes you could see them perfectly.
Exactly.
There is a possibility in this case that as she was walking out, if the defendant was standing in front of the door, that she could only see a silhouette.
Well, yes, that's a possibility.
That's a reasonable possibility. It's not just a possibility that is remotely possible. It is a possibility with some likelihood, and I think she's allowed to explore those possibilities, particularly with the witness who wasn't there.
I agree with the court. What concerns me is the assumptions upon which many of these possibilities are being put forward. And true, you have photographs, but I would submit that the photographs are not reliable evidence as to what one sees in the human eye. Photographs, particularly with the silhouetting and the lighting in the background, give a far
I'm not
different picture.
concluding that this was the fact. I'm merely concluding that this is within a reasonable range of inquiry. That's all.
And my original objection went to the fact that her statement tended to rely or state evidence which was not stipulated to her, which was not put forward. That is, that Rebecca Schaeffer could not see within the distance of, let's say, a foot, 12 inches or 2 feet.
She has corrected that since that time. And I also stated that she should ask the question as a hypothetical. All right?
Yes.
Doctor, in saying that you find corroboration for the fact that the first visit went well in the fact that she opened the door to him the second time and stepped out onto the porch, you are assuming, of course, that she saw him standing in front of the glass door when she walked down the hallway and when she opened the door, aren't you?
Yes.
And you yourself have taken care to review the photos of the crime scene, have you not?
Yes, I have.
And you have seen that the door that we are speaking of is a glass door, have you not?
Yes.
Have you gone to the crime scene?
No.
Have you also seen the photographs that were taken from inside the apartment from a perspective that looks to be somewhere down the hallway looking towards the door from the inside of the building?
From inside the building, but not from inside the apartment.
From inside the building. You've
Yes.
seen those photographs.
Yes.
And from what you have seen, is it not a reasonable assumption that if someone is standing in that hallway and looking towards the door, if someone is...
Nancy, they're trying to figure out if she knew who it was when she answered the door to him the second time.
standing in front of the door, they can at least see a silhouette, at least.
At least at the time of day those were taken, yes.
And you know that this crime occurred at approximately 10 o'clock in the morning, do you not?
Yes.
And you know from the evidence that was taken that it was a bright, sunny, hot day, do you not?
No.
No? Did you read the preliminary hearing transcript, sir?
Yes.
Did you read the testimony of Ed Villery?
Yes.
Do you recall him testifying that it was a hot day?
No.
Do you recall any of the witnesses testifying to the fact that it was a bright day?
No, but I knew it was sunlight.
Then given the fact that you knew that it was sunlight and what you have seen of the crime scene photographs, can you infer that someone standing inside the building and looking towards the front door could at least see a silhouette if someone stood in front of that front door?
Yes.
Then I return to my earlier question, Doctor. You have assumed, have you not, that Mr. Bardo was standing in front of that front door when Rebecca Schaeffer came to it, in saying that her opening the door to him constitutes corroboration for your theory that the first visit went well, correct?
Correct.
If in fact your assumption is incorrect, and Mr. Bardo rang the bell and stood off back to the side behind the bushes to await her exit from the door, then in fact your conclusion concerning the nature of the first visit, and indeed your conclusion concerning his purpose for returning, would be false. Isn't that correct?
Yes, it is.
Now, how about when the defendant told you that he loaded the empty chamber, stripping the gun of what he called its safety feature, and said he thought, let's get this over real quickly. Did it occur to you then that this does not show someone who anticipates a friendly conversation?
Yes, of course.
Did you confront the defendant with that thought?
I don't recall if I confronted him with it, but I certainly tried to clarify what was going on.
And how did you do that?
I'm afraid I can't recount that to you in detail without reference to notes or the videotapes.
Let me ask you this question, Doctor. You indicate that it did appear to you significant and somewhat contradictory to what the defendant was telling you he planned to do on the second visit when he said that he loaded the empty chamber and went back to the door and thought, let's get this over real quickly. Did it occur to you at that time that the true purpose for the second visit was to kill Rebecca Schaeffer and not to have a pleasant encounter?
Well, that's of course not all he said.
I agree. It's not.
There's a great deal of other material there, and yes, it did occur to me that that is one of the possibilities.
Did you pose that as one of the possibilities in speaking to the defendant?
No, it's a straightforward enough one.
I'm sorry?
I don't think he needed any reminding that that was a possibility.
Did you say to him, Mr. Bardo, you just told me you loaded the empty chamber, stripping the gun of what you thought it was its safety feature, thought to yourself, let's get this over real quickly. And I know you told me other things, but that sounds like you meant to go back to kill her, Mr. Bardo. Is that what you meant to do? Did you do that?
I don't think I was that confrontational with him.
In previous forensic examinations, sir, you have been that confrontational, though, have you not?
Yes.
As a matter of fact, in the Hinckley case, you were that confrontational, were you not?
I don't recall, but I may have been.
As a matter of fact, in the Hinckley case, do you not recall confronting the defendant with inconsistent statements that he made in police reports and inconsistent statements he made to other psychiatrists?
Yes.
You did not do that in this case, did you?
No, not in anything like the same detail.
Did you ever ask the defendant when he just traveled from a dangerous area like Union Station at 4 or 5 a.m. with an unloaded gun, why he had suddenly felt the need to fill up the one empty chamber before going to see the girl he loves and expects to receive him warmly?
No, actually, I was confused about it because before seeing him, I'd read a statement in which he said he loaded it at the bus station. And then later in the course of seeing him, he told me a different story about when it had been loaded.
So there was an apparent contradiction there, was there not?
Yes.
Did you ask him to explain it?
I don't recall if I did or not.
You don't remember whether you asked him to explain inconsistent statements made to you and to the police 2 years earlier?
I don't recall which particular things I may have asked him about.
Doctor, do you think it's important when you find the defendant has told you statements that conflict in material and even non-material ways with statements he'd made earlier to the police?
Do I think it is important?
Yes.
When that happens?
Yes.
Yes, I do.
And don't you think that it might be an important way for you to assess the defendant's credibility and veracity in the statements he gave to you to probe that issue?
Yes, I do.
And you did not confront him with that contradiction with regard to when he loaded up the gun in this case?
I don't know if I did or not.
Do you need to refresh your memory with your notes?
If it's, well, I don't know. I don't know if that'll shed any light on it or not. What I do know is that the circumstances were such that I did not have a list of contradictions to confront him with, which is ideally how that would have been done.
Nevertheless, in your testimony, you pointed out what you thought was a contradiction, as you've done today, in the fact that he told the police that he loaded the gun in the bus station and told you that he loaded it in the neighborhood.
Correct.
And you did not point that contradiction out to him.
I don't know if I did or not.
And you have no way of refreshing your memory to tell us whether or not you did?
Not unless it's on the videotape or in my notes.
In other words, if we did not see it on the videotape, then you did not do so?
No, that's not what I said. If it is in my notes from day one, then I may also have done so. If it's on videotape number 2 from day 2, then I may have done so. But if I did it on day one and it's not in my notes, then I won't be able to refresh my recollection of it.
You mean that you may have confronted him as to a direct contradiction between the two statements given to you and to the police and not made a note of it in your notes? Is that what you're saying?
I think that's possible.
Let me ask you then from a logical point of view. Did you ever confront the defendant with the illogic of a statement in which he indicates that he traveled through a dangerous place like Union Station, at least partially in the dark at 4 or 5 a.m. with an unloaded gun, and then only fully loaded it before he went to see Rebecca Schaeffer, and explained that to you by saying it's because he was going to go back through Hollywood, but in broad daylight? Did you confront him with some of the obviously illogical conclusions in that statement?
I did not, because on many of these things where, where it's a question of his being illogical, I took that as confirmation of mental illness. He's illogical about many things.
Doctor, when a defendant gives you a statement that seems preposterous and may constitute a lie, are you telling me that you can tell the difference between someone who is giving you an illogical statement because they really believe it because they're nuts, and the difference between a defendant who is giving you an illogical statement because he is lying and seeking to protect himself?
Well, without making any claim to being a lie detector, there are times that one can make that distinction, yes.
And there are times that one cannot, isn't there?
Yes.
And in this particular case, in telling you, in making statements to you that appear to defy logic, like the one I just pointed out, the defendant may well have been lying to give you an excuse that seemed innocent for very culpable conduct. Is that correct?
That's possible.
Did you ever try to confront him in a manner that would tend to elicit the fact that he was lying to you about these statements?
About some things I did, and I can't tell you from memory which things that I confronted him about.
You think you confronted him and you can't remember when or how or about what?
I would have to review notes and review 4 hours of videotape to begin to answer that. I know I've pointed out some contradictions. I was never nasty and confrontive in the way that you described earlier, but I did point out some contradictions.
Oh my God.
Well, no, doctor, when I say being confrontive, I don't mean you've got to yell at the guy. I'm just talking about pointing out, well, Mr. Bardo, you just told me that you traveled through Union Station in probably the dark with an unloaded gun, but that you were going to load it all up and be ready to go back through Union Station in broad daylight. And coincidentally, you just happened to do that before you went to see Rebecca Schaeffer the second time. That's not nasty, is it?
Objected. No.
The doctor used the word nasty, so I'll allow the question.
I think
That's pointing out an inconsistency, isn't
I
it,
think
doctor?
those words could be said in a way that was not nasty, yes.
All right.
Well, doctor, what about the way she said them just now? Do you think that's nasty?
Just now, not particularly.
All right.
He came to testify about his interview with Bardo, but he doesn't remember half of it. Why didn't he bring... Look at all the papers he's got. And he doesn't have notes or reports or whatever about anything the prosecution is asking him because he's a paid mouth for the defense. It's ridiculous. Absolutely ridiculous. He should be able to testify and answer questions from both sides. He's getting paid by the defense. So what? He should still be able to answer the questions from both sides. This kind of crap, if I was on a jury, this kind of crap would make me totally not want to credit his testimony at all. Because, and Like, I know that they have to get paid. Like, this is what they do for a living. They get paid to do this. I get that. And it doesn't bother me that they get paid. But in this case, usually paid experts will answer the question from the other attorney, the one they're not paid by, will answer questions and cooperate and not be, most times, not be confrontational or stupid like this guy is. I say most times, not all the time. We saw that in the Karen Reed trial. But this guy is like, I don't know. I would know if I had my notes or if I took notes or whatever, This kind of stuff, if I was on a jury, I'd be like, no, he's clearly hired by the defense. Every time she asks him a very pertinent question, well, I don't know. I'd have to look at my notes if I took notes on that. No, absolutely not. I would not listen to the thing this guy said, which I think, like, the judge has not asked. He's asked questions of other witnesses, but nowhere near as many as he's asked this guy. So the judge is catching on to the same thing, that he's not prepared to ask any question, or not prepared to answer any questions almost that the prosecutor's trying to ask him. So the judge is jumping in and asking questions too, because he just is like, nope, I'm prepared to answer the questions that the defense is asking me, but I'm not prepared to answer any of the questions that the prosecution's asking me. It's a waste of time. Gosh, I can't stand this guy. Like, I was like, well, he's not as arrogant and as irritating in this trial. But at this point, I'm just as irritated with him because he's not prepared to answer the prosecution's questions. Oh my God, you're driving me nuts, dude. I think it's time to stop anyways. It is. It's time to stop. Because we have to go to Brian Walsh's sentencing hearing now. Gosh, this guy is insufferable. I can't stand him. Even when his personality is not being aggravating, he's still being aggravating. He's just, it's almost like he was like, no, I'm testifying for the defense, so I don't have to get ready for any questions that the prosecution might ask me. What part? Are we still in part 13? We're still in part 13, y'all. God bless America. Dude. I keep wondering if this guy is married. Who would marry this guy? Do you guys see a wedding ring on him? Do only women think like that? Like, who would marry this guy? Is that a female thing? Oh, yeah. A gold digger would marry this guy. You're right, Wiggles. Okay. All right. So, it should redirect for everybody but Marty. I don't know why it doesn't redirect for Marty. Okay. So, I'll see you over there in a few minutes. Bye.